Commonwealth v. Randall Lewis, SJC-11500.
Yes, counsel.
Good afternoon, Your Honors. May it please the Court, Vincent Demore on behalf of the Commonwealth, and I'd ask to reserve 2 minutes on rebuttal, if I may. I'd suggest in this case, it's instructive to begin with an understanding of what this case is really not about. It's not a case where a discovery order was made that is either barred by a statutory or some common law privilege, and it's not a case where the discovery being requested is something that the Commonwealth is suggesting is not potentially relevant or material. And there's been no showing of either of those two things, but that's not really at issue either. Rather, this is a case where the order itself does two things. Firstly, it robs the Commonwealth the ability to comply with the order in conformity with the requirements of Rule 14 by making the records available for inspection and copying, and simultaneously, since it was ordered under Rule 14, robs the state police of the ability to file a motion to quash, since it's not a Rule 17 order.
So, and why, I saw that below, it was argued as a Rule 17 order. What makes it a Rule 17 order?
It's not a Rule 17 order.
Because I saw Ms. Terry argued that it was.
Well, yes, so the motion itself was not filed under the auspices of Rule 17. Judge Somerville was very clear that he viewed it as mandatory discovery under Rule 14. Our position was that it isn't mandatory discovery under Rule 14, that it's not in the care, custody, control of the Commonwealth, and that, therefore, in order for it to be ordered, it has to be ordered pursuant to Rule 17, which would then give the state police the opportunity to file a motion to quash.
Well, the fact that it's not mandatory discovery doesn't mean that it couldn't be discretionary discovery.
Oh, no, absolutely.
Under Rule 14.
If, in fact, the court finds that that the material is in the care, custody, control of the Commonwealth, and I'll indicate there's really been no showing of materiality and the like, but setting all that aside, I think down below we conceded that as well, that
Okay, so
certainly under these circumstances.
Your real argument is it's really about the Rule 14, and since Rule 14 allows the Commonwealth to offer to make it available.
Yes. That's fun. I mean, I'm happy to have a case that's not particularly complicated at this point, but I think that's really what it's all about.
Sort of practical and legal consequences of that.
Exactly. And as it stands, the order is really this hybrid Rule 14, Rule 17 order that takes away the ability of the Commonwealth to comply in a way that would be the ordinary way we would comply, but simultaneously robs the keeper of the records, the state police, so to speak, of the opportunity to file a motion to quash. And at the end of the day, and I do want to reiterate this, it's not our position that the defendant can't have these records. We'd be more than happy for the defendant to have these records. It's really a question of sort of the allocation of the burden in terms of who essentially makes the copies. And while that may seem like a very, very trivial thing, and I would suggest that in many contexts it certainly would be something that's trivial, Rule 14 explicitly provides us with this particular avenue of production to simply make them available for inspection and copying. And I'd suggest there's nothing about the rule that suggests that discretionary discovery puts some greater burden on the Commonwealth in terms of the nature or the mechanism of production. But I think in the larger context of the lab at Sudbury, I think that's something that shouldn't really escape the court's attention.
So now Sudbury is doing not only what it was doing, but all that was going to the Hinton lab.
Until the Amherst lab is up and running, which hopefully it'll be about a month, they're doing everything in the state, with the exception of some Worcester County things.
Just talking about practicalities again from the other side, what's so hard about making a phone call to the lab to say, look, we've just gotten this order? What do you say about that? I mean,
Sure, the direct answer to the question is nothing. right? There's nothing hard about making a phone call to inquire with respect to that. The reason why this was ultimately litigated was when the order was first made, the lab informed us of what they do is that, they make these available for people to come in and take a look, and they can inspect and copy them as they like. And it's not an issue of, in this one case, is this a problem? In this one case, maybe we're talking about 25 or 30 minutes worth of somebody's day to make these photocopies.
Well, it's 2 weeks' worth of records, right?
4 weeks total,
I
2
mean,
weeks
that's what I
before,
mean,
2 weeks after.
4
Yes.
weeks' worth of records.
And it's been indicated to us, it was represented below, that it's a voluminous quantity of documents. That's kind of a squishy term so far as I'm concerned. I don't know exactly what
Well,
that
it was
means.
voluminous when it was going to be a year,
Yes,
6 months and 6 months.
yes. So I don't know if it's still voluminous but less voluminous. I'm just not sure, and I don't want to make any representations that I simply don't have the information for. But the problem is that it's not just one case. Every month in the Commonwealth, there are 1,500 samples submitted for analysis to the Sudbury lab, a lab which is only physically capable of testing 500 per month with a 15,000 sample backlog. So if these records are ordered produced on a regular basis whereby it's the burden of the government to physically make the copies, the administrative cost of that would be overwhelming. And since it's not a Rule 17 subpoena, and if it was a Rule 17 subpoena, then they would have to produce the copies, send them to the clerk's office. But the state police would have an opportunity to file a motion to quash and essentially be able to do something about that.
Could I ask you this? I forget the date that this order happened.
March?
I'm just wondering how frequently this kind of order has entered in Suffolk's experience.
Sure. So when this order was made, and I think it was the beginning of March or the end of February of 2013, there was an expectation that these requests were going to become commonplace, because candidly what we see is precisely these same motions being filed on every drug case as they're circulated on the CPCS listservs and the like, which is why I was asked to file a 211-3 and proceed here. Candidly, we really haven't seen much of it since then. I was surprised.
There's much of the requests being filed, or much of the orders entering?
Both. We haven't seen as many discovery requests of this nature as we anticipated. And I think by and large, the trial courts have simply essentially done what we've asked at these hearings, which is they can go take a look anytime they'd like, just make an appointment with Sudbury. So if there are no further questions at this point, I would just rest on the papers.
All right, but you'll be back again.
I'll be back.
Because you reserved some time.
It's not so easy to get rid of me.
Okay, thank you.
Good morning or afternoon, Your Honors. May it please the Court, Attorney McNiff representing Mr. Lewis. Rather than elaborating on my own argument in Mr. Lewis's red brief, on which I rest, I would like to address a couple of points brought up in my brother's argument. First of all, he's going outside the record in letting the Court know about these many other cases. If that was a concern of the Commonwealth almost a year ago, they did have their opportunity before going to the single justice. Remember, there were 3 different motion hearings here. They did have their opportunity to document to some extent over a 2 or 3 month period of time before going to the single justice just what their concern was in how many of these cases about which we're hearing now as a category, about how many of these cases they were seeing. I heard some talk about their expectation that they were going to see many more of these motions. We've heard nothing about that. And on the record, through the conclusion of the briefing, we didn't see, I've made this point in the brief, I think it bears repeating now, because even though we get more hint, more vague allusion to extra record evidence, we still don't hear any names, and we don't know exactly what the problem is. In fact, with respect to this case, I think we've heard something which helps the defendant that we haven't heard before. There's nothing particularly burdensome about this order. I think
Actually,
the specification...
it actually does sound burdensome.
15 or 20 minutes, Your Honor, for one case.
Well, the original request was for 6 months before and 6 months after. I think it was the judge who was it the judge who limited it, or did counsel limit it?
It was a defendant's counsel at trial volunteered the limitation. And I think we might say, on the basis of comments that Judge Somerville made on the record roughly concurrently with that volunteering, perhaps he would have required that sort of limitation, even had defense counsel not volunteered. But in fact, defense counsel volunteered. There was no bargaining going on here. We don't have the Commonwealth suggesting any limited period. It's the defendant that volunteers that. And then Judge Somerville, without offering any other shorter or longer specific period, just says something about being reasonable, practical, or some other term. The second point, I did say that I wanted to comment on 2 points I found raised in my brother's remarks. I hear again about Rule 17 today, and as I pointed out in my briefing, there was nothing in the blue brief in this court about Rule 17. There was a reliance on Rule 17 only on the Commonwealth's part, only at the third of the 3 hearings. I detail this as a matter of record in the briefing. I think it's significant because you only see Rule 17 cropping up in the record at the last of the 3 hearings. You do see Rule 17 in the petition. The single justice specifically acknowledges the presence of that Rule 17 argument and then goes on to reject the argument, rightly, of course, I contend. And then before the full bench, the Commonwealth says not a word about Rule 17, and yet it somehow sees a need to revert to that trial court petition argument again today. So, I mean, we have to wonder what really is the Commonwealth's position here. And if it is a Rule 17 argument, why did we not see it in the blue brief? Unless there are any other questions from the court, which of course I do my best to answer, I will rely on the briefing.
All right, thank you, counsel.
And good afternoon again. With respect to the record is what it is in terms of the completeness below, and I candidly don't have much in the way of comment with respect to that. To address the Rule 14, Rule 17, why Rule 17 appears here and not there, and the like, I think there's actually a really simple answer to that question. The order below in the BMC was an order which was essentially based upon an imaginary rule of criminal procedure that doesn't exist, that looks kind of like Rule 17 and looks kind of like Rule 14. So I think there's essentially by the nature of the trial court's order below, the sands below the Commonwealth's feet kind of shift back and forth in terms of exactly how.
When you say it doesn't exist, you mean because it didn't give the opportunity to make them available?
If it's issued under Rule 14, then the avenue of compliance is either to produce or allowed to be inspected. If it's ordered under 17, then the keeper of the records has to produce copies of the records to the clerk's office, certified copies. But where you're essentially requiring the Commonwealth, and when I mean the Commonwealth, I mean the Office of the Suffolk County District Attorney, to produce the records, then that has to be under Rule 14, since we're not the third-party keeper of the records, so to speak. But we're not allowed to do so in the way that we would do. In terms of what I'm really asking the court here to do, which I really should have mentioned this right at the beginning, is what I'm asking is simply for the court to give effect to Rule 14 and to find that the Commonwealth's position that these records are available at the convenience of counsel for copying and inspection whenever they'd like, that constitutes compliance with the order, and that the court would strike the portion of the order that requires the government to produce copies of the records.
Thank you, counsel.
Thank you.